Well, I'm really energised right now. I think I'm going to go and sign up to law school. I'm really energising. And I too want to acknowledge the traditional owners of the land on which we meet, the Wurundjeri people. But also I want to acknowledge all of those in the room who've actually worked in the space that Nic was speaking about, who've been the lawyers who have represented Indigenous clients or the Indigenous movement in moving people forward. Because actually some of you are in the room tonight. I looked at the program when I thought, well, what am I going to say here? And the program said, that we're here tonight to entertain and engross you in a matching of the minds, to inspire you to think differently about law and social change. Now, apart from being a mouthful and me having to follow Nic, who probably has done that, I think actually that the premise upon which we approach this question can sometimes be wrong. The premise being that you, and I'm talking about you as lawyers, I know not all of you are, but let's make the assumption for a minute, you are the ones who need to change. At GetUp, you might know that we've just been through two big cases, both in the federal court and the High Court. The first time that in our humble movement that we've been able to use the law to get the social change outcomes that Nic spoke about. And one thing I saw was that there was no shortage at all of lawyers who would sign up to be part of a good case, who would sign up to be a part of social change. And so therefore my mind turns to the question of how do we get more people asking lawyers to jump on board? How do we actually get more people involved, more social change organisations involved in the idea that the law can be a great tactic in social change outcomes? So I think what's really key here, though, is in building the legal literacy, and maybe you have a role in this, in building the legal literacy of those who are involved in campaigning. Oh my God, I'm just noticing that. Did that just come on? Was that on for you, Nic? Was that on for him? Oh my God. Sorry, I'm down. What was I saying? That is extraordinary. I'm going to have to look this way now. I should have put the makeup on too. Anyway, I do think there is a role to play here around legal literacy. And I was having a conversation with Phil Lynch from the Human Rights Law Resource Centre today, earlier on today, with Fiona as well. And it was a really interesting conversation because what they pointed out to me is that the cases we were involved with and a whole raft of public interest cases actually rely on social change organisations not only asking the question of lawyers in the first place, what can be done, but playing an active role. See, at GetUp, I think our role in the cases that we've been a part of has been really important because lawyers can't run cases, big public interest cases on their own. You need a client, some test litigants, preferably some ones that are going to look good in front of the judges and are going to get the job done and are going to look good in the media and all of these things that are important. So therefore, there's a lot of work that's required to find those people. Also, in addition to that, in the case of the enrolment work that we were doing, it was also really important that you had a movement who could build a really large group of affected people. Not just that those people would exist, but actually tap into those, and in our case increase those by asking lots and lots of people to enrol to vote in the 7-day period that was previously closed. That was actually fundamental in the High Court case that we ran because it was one of the tests. The significance of the class of people affected was actually one of the tests. So another role for social change organisations. The big one, we need people to indemnify those who are actually going to move forward with legal litigation to get something done, and that's something we were able to do, although it was a big and scary risk. And finally, it's really important that we build bridges between activists and lawyers, because once test case litigation, to take that as an example, is done, once we're successful in public interest advocacy, then there's actually some non-litigious work to be done after the case. It's quite obvious to ensure things actually get done. In our case, we've got to make sure that at the next election, hundreds of thousands of people actually know about and take advantage of the new provisions that allow people to enrol to vote in an extended time. And so I think it's pretty obvious in all of that that a relationship between you and I, but also between others out there, is absolutely crucial. Much of our thinking at GetUp about the question of whether or not we can use legal advocacy, indeed much of the work that we do at GetUp as a whole, is inspired by what we see in the US. And not just the t-shirts that Fiona held up earlier, but in fact the very long history of using the law to achieve social change outcomes that actually exists in the US. We can cast our minds, I think, to two really key examples that probably highlight something that could grow in Australia, that is the use of legal advocacy by really big organisations. The ACLU, which is the American Civil Liberties Union, for those who don't know it, one of the biggest organisations in the US, actually started as a quasi-law firm a really long time ago. The only thing it would do is use the law to achieve social change outcomes. It actually went the other way round and decided that it was when you do legal work and advocacy work combined that you get power, whereas in our case we're going the other way around. You look at some of the size of what's been achieved, part of which Nic was referring to earlier. The internment of Japanese citizens in World War II, establishing a woman's right to choose in the really landmark Roe versus Wade case in the US, protecting Guantanamo detainees, for example, from torture and abuse. I'm reading David Hicks's book at the moment. I don't know if anybody else is, but an extraordinary book about what was happening and about the role that lawyers played. The highlight of his, I would say day, but really it was years, was when lawyers walked into the room and had a conversation with him about his rights and documented what was going on. It was in fact lawyers that inside Guantanamo Bay, in addition to chaplains in fact, who were able to be very effective in moving forward a situation where fundamental human rights weren't being met. The NAACP, I think, is also another extraordinary example that, in fact, we don't really look to enough in Australia. This is the National Association for the Advancement of Coloured People. It's not just in Australia that the law has been used to enhance the rights of the first peoples of the world. For more than 60 years, they did some extraordinary things. For example, getting rid of laws through the courts that mandated lower pay for African American teachers, extraordinary thing, that mandated the separation of blacks and whites in schools, that prevented black Americans from exercising the most fundamental political right, that is the right to vote. And I think when we look to Australia, while we see some examples, some big examples of the law being used in this area for social change, I wonder in the context of what I've just said there, looking to the US, why we don't see so much more. And I know I'm supposed to be the wise person here giving you the answer, but actually I really don't know. I really don't know exactly why that isn't occurring here in Australia, and so I'm really looking forward to that conversation. But in some way, perhaps the story of what we've been doing in the last few months with the law may offer some examples of where it has worked. We had been campaigning for years in the area of trying to improve the way our enrolment system works. Why? Because we were absolutely amazed at the fact that 1.4 million people at one stage just earlier this year weren't on the electoral roll. There are about 14 million people or less that vote at any election. 1.4 million, 10%, were not on the electoral roll. An extraordinary thing. They were disproportionately Indigenous, disproportionately migrants and recent arrivals to Australia, disproportionately homeless, as well as disproportionately poor. The very people that surely our laws and our parliament should be working to improve the stance of. 50% of 18-year-olds weren't on the electoral roll and still aren't on the electoral roll. An extraordinary thing that it's a responsibility, and yet half of all 18-year-olds aren't on the electoral roll in the first place, not exercising the most fundamental basic right. So for years we campaigned to improve the situation, in particular to get rid of an outrageous law that's called, quite ironically, the Electoral Integrity Act. This was pushed through by Senator Abetz, a coalition senator from Tasmania. I'm seeing some smiles and some nods. I take it you understand part of what that was about. This limited the capacity of someone to enrol to vote in the 7-day period following an election, which is where, as you might guess, the majority of people do enrol to vote or update their details when they actually think about the election. He cut this off, potentially because those people who were enrolling late weren't the kind of people who would vote for him, although the statistics prove that that's not quite the case. He cut this off, and for years we went through the parliamentary procedures of trying to convince people to change the law. At some point we got the ALP to commit that if they formed government, and they eventually did, that they would change the law. They put it up, it failed. I can say thanks to you, being Victorians, because it was Senator Steve Fielding, the elusive Senator Steve Fielding, who blocked it.